Distressed borrowers in today's credit market face an environment of immense pressure. When liquidity dries up and default risks spike, companies are forced to look for any available escape hatch to survive. To understand how they find that escape hatch, we have to look at the standard capital stack. Traditionally, a company's debt is structured in strict tiers. First lien debt sits safely at the top, followed by second lien, down to unsecured debt at the bottom. But when a borrower has no unencumbered assets left to pledge for a new loan, they search the fine print of their existing agreements. They exploit loose covenants to fracture this top tier, dividing their senior lenders into two opposing factions, the participating haves and the excluded have-nots. This triggers a scenario known in the industry as creditor-on-creditor violence. The participating faction agrees to inject fresh cash, but only in exchange for new super-priority debt that violently shoves the excluded lenders down into a subordinated position. Borrowers execute these maneuvers using two primary structural vectors, dropdowns and uptiers. Liability management exercises, or LMEs, bypass the expected legal protections of syndicated loans. They pit lenders against each other, sparking an ongoing contractual and judicial arms race in leveraged finance. The primary objective of a drop-down transaction is to isolate valuable collateral, moving it completely out of the reach of existing lenders to secure fresh financing. A parent company connects to restricted subsidiaries inside a security package pledged to lenders, holding high-value collateral like intellectual property. Exploiting loopholes, the borrower forms an unrestricted subsidiary outside these boundaries and physically transfers that I-key into it. Alternatively, borrowers don't even need to move the assets. They can strategically redesignate an existing restricted subsidiary into an unrestricted one, achieving the exact same result. Alternatively, borrowers can strategically redesignate an existing restricted subsidiary into an unrestricted one. Now that the intellectual property sits in an unencumbered entity, a new lender can inject cash specifically secured by that liberated collateral. In a matter of signatures, pre-existing debt is stripped of its primary collateral backing. The issuer raises essential capital without supplying genuinely new assets. Up-tier transactions operate differently. The collateral remains stationary. Instead, the borrower rewrites the actual hierarchy of the debt. A unified consortium holds all first lien debt. The borrower acquires a bare majority, breaking lenders into participating and excluded factions. This majority creates a legally superior claim. Participating creditors take this new super senior status at the top, severely subordinating the non-participating creditors below. Because these non-pro rata exchanges exclude nearly half the creditors, they carry intense litigation risk and judicial volatility. The courts are stepping in. In the Certa case, the Fifth Circuit recently reversed a trial court decision, ruling that an up-tier did not qualify as an open market purchase. The court found they could not use that exception to bypass provisions requiring unanimous consent. In the Wesco and Incora bankruptcy, a court ruled that isolating amendment steps to create a voting domino effect constitutes an unlawful release of liens. Uptiers offer distressed companies a fast liquidity solution, but courts are aggressively scrutinizing the boundaries between loose contractual flexibility and unauthorized end runs or unanimous creditor consent. The credit market is not waiting for judges to solve the problem. Lenders are retrofitting their debt documents with specific anti-LME blocking clauses. To stop dropdowns, lenders use provisions like the PetSmart or Chewy blocker. Reading this credit agreement, it states a guarantor cannot be released solely by becoming a non-wholly owned subsidiary through a de minimis transfer of stock. This clause directly targets the dropdown strategy. It restricts the issuer's ability to release a subsidiary guarantor by nominally transferring its equity to an affiliate. However, this blocker relies heavily on whether the transfer has a bona fide business purpose, a highly subjective legal definition, leaving room for borrowers to maneuver. To prevent up-tiers, lenders deploy the Certa blocker. This indenture forbids any amendment that would subordinate the liens securing the obligations without the prior written consent of each directly affected lender. This establishes a sacred right. It requires unanimous written consent to enact any amendment that indirectly subordinates existing liens. Borrowers have found ways to attack this too. In the Wesco Incora exploit, borrowers dilute voting power by issuing additional notes to friendly parties, manufacturing the required consent thresholds. To neutralize that specific vote rigging tactic, lenders drafted the Wesco Incora blocker. This document explicitly states that any notes incurred substantially concurrently shall be disregarded for determining voting compliance. By forcing concurrently issued notes to be ignored during a vote, the clause prevents borrowers from artificially padding their majority. The most recent evolution is the omni-blocker, an emerging strategy aiming to ban all non-pro rata liability management transactions outright. Despite these innovations, empirical data shows fragmented adoption. Borrowers fight to maintain optionality, often successfully watering down these blockers with numerous exceptions during negotiations. Third-party architects of these restructurings now face direct legal targeting as the fallout from LME litigation expands. This diagram highlights the dual role of private equity sponsors. The sponsor wields operational control over the portfolio company, extending to the borrower's board. Simultaneously, the sponsor holds a massive financial stake as a participant in the priming debt exchange. This dual position creates clear litigation vectors. Excluded lenders are pursuing claims of tortious interference and breach of fiduciary duty directly against the sponsors. Courts are taking notice. In cases like Wesco and Certera Holdings, judges are increasingly rejecting the traditional economic interest defense when equity sponsors leverage their board control to benefit themselves as debt holders. To insulate against allegations of self-dealing during liquidity crises, sponsors are now frequently forced to appoint independent board members to evaluate restructuring proposals. Leveraged finance remains an escalating arms race. Distressed borrowers exploit covenant loopholes, lenders fortify with blocking technology, and courts draw the line between aggressive strategy and actionable theft.